Chair Harmon and Commissioners, Mitch Silverstein with Surfrider Foundation. On behalf of Surfrider and the public beaches we protect, I ask that you support staff's recommendation and deny these requests. A reconsideration can only be permitted if there is new evidence or if an error of law or fact has occurred. On new evidence, staff clearly articulates that no new evidence was presented that wasn't already in the record at the time of the original hearing. The applicant argues that Commission staff erroneously testified that the bluff is made up of marine terrace deposits rather than non-marine terrace deposits as well. However, this distinction is immaterial because Laguna Beach's LUE makes no distinction between or mention of the underlying sediments of a coastal bluff in determining the bluff edge. Coastal bluffs form through erosion regardless of, no matter what the eroded material is made from. As for the error of law argument, the applicant contends that the Coastal Act and Laguna Beach's LUE only regulate development on natural landforms, and since the bluff has been altered, no bluff edge can be determined. However, the city's LUE explicitly states that bluff edges change due to, and I quote, erosion, landslides, gullies, and grading, end quote, clearly anticipating altered bluffs. If bluff edge determinations only apply to pristine slopes, I could probably just shovel some fill on a bluff and say, look, it's been altered, now the Coastal Act doesn't apply anymore. Clearly that would be absurd and contrary to the Coastal Act's protective intent. In any case, the Commission's geologists based their determination on historical maps from before any of these unnatural alterations occurred. The Commission's geologists determined the bluff edge is at 150 feet elevation, the point where the slope of the topmost step ends and becomes relatively level. Because this bluff does have a step-like character, the LUE requires identifying the bluff edge at the landward edge of the topmost step. The bluff edge determination in its location has been on record for 6 years. It was established in 2019 following a substantial issue hearing for the adjacent property that shares the same bluff edge. Therefore, the Commission's determination remains correct and consistent with the city's LUE and the Coastal Act. There is neither new evidence nor error of law to substantiate this request. Proper bluff edge determinations protect sensitive coastal resources and help avoid the need for future shoreline armoring that would sacrifice public beaches to private development interests. Surfrider urges you to deny this request. Thank you for the opportunity.
That's all the public comments for this.
Great, thank you very much. Okay, well, I will return to our staff. Do they have any closing comments?
Thank you, Chair Harmon. So, hearing what we've heard today, staff didn't hear anything new that wasn't previously addressed in the staff report and recommendation in the hearings on these matters. I want to point out that there's nothing unusual about the way the bluff edge setback policies were applied in this case or in these cases, nor the manner of the bluff edge identification itself, which is based largely on topography. We responded fully to the comments that were provided here as well in the addendum. I do want to point out that this particular proceeding is not an opportunity to revisit the bluff edge determination that was made by the Commission at its hearings on the CDPs. We're simply looking at the narrow question of whether the requests here meet the grounds identified in the Coastal Act. On the bluff edge determination itself, I'd point out that our geologist has many, many years of experience doing these things. So his determination was in line with prior determinations on these sites. There was a prior determination of the bluff edge location in the context of a prior appeal on these sites. And the determination made in that case by a prior staff geologist is on point with the one made here today, or made in the Commission's actions. And I think with that, I don't know if we have any further comments from our staff counsel.
Yeah, I would just like to add that the fact that the Coastal Act protects natural landforms does not mean that the Commission can't identify a bluff edge on a natural landform that has been altered. The fact that, I mean, it is still at base a natural landform. They didn't create the entire bluff there. It is a natural landform that has been altered. And also to note that even if the applicant were right about the Coastal Act interpretation, LCPs can be more protective than the Coastal Act itself, and it's really clear that this LCP policy identifies the bluff edge determination, including if there's been fill or cut. So it takes into account the potential for alteration of the natural form.
Thank you very much. Okay, I'll bring it back to the commission for comments, questions, motion. Commissioner Escalante.
Thanks, Madam Chair. I'll be brief. I just want to echo, I think, everything that Mr. Silverstein said. That's sort of what I was thinking, and just to add, what I think is unusual is the lengths to which folks have tried to push a big giant cube into a small hole. I've never seen a funicular connecting a garage to a downslope home. So I really do hope that they take to heart the Commission's intention on this, not just to protect the precedent of now 50 years since we're celebrating, but also protect the safety of those who live on and near the bluff. So thank you, staff, for your thorough review and your thorough work, and I appreciate it. Thanks.
Vice Chair Hart.
Thanks. I'm ready to make the motion, and I would just, in my mind, the clearest point here is the one that was just stated by our counsel, which is there hasn't been anything presented that is new that would justify reconsideration at this time. We're not here to relitigate the original decision by the Commission, and based on that, I'm prepared to make the motion.